So in this video, we're going to talk about what happens when the executor of an estate just isn't getting the job done. All right, so I'm Paul Rabalais. I'm an estate planning attorney. I help our clients get and keep their legal affairs in order. And some estates tend to go on for years without being settled. And that could be for a variety of reasons. Could be because of poor relationships between all of the parties that are involved, the heirs, the executor, and other parties that are involved. Could be that people who are supposed to be doing certain things, the executor, for example, they're not doing them. Could be because of a lack of communication among various parties. Or sometimes things just stall because people stall. Either heirs stall, lawyers stall, judges stall, executor stalls, courthouse employees, financial institutions, all that. If there's just a kink, then things tend to go on, in many cases, for years without being settled. So a question I got from someone who made a note to one of the posts on the communication tab of my YouTube channel, and her YouTube name is a fixer-upper fool. A fixer-upper fool asked, what are the rights of a beneficiary if the executor refuses to communicate? So this goes into this big discussion of what if the executor isn't getting the job done, things aren't being settled, what recourse, if any, do the heirs have? All right, so a couple of preface points before I get into the nitty-gritty detail. One is just, if you haven't already done it, punch the subscribe button and the notification bell. That way you won't miss anything. And then just tune in every morning, 10 a.m. Central Time, more educational estate planning videos. Okay, so this conversation, I want to get through some of the lingo. When someone writes a will and names someone to oversee the settlement of their estate, that person's called the executor. When someone doesn't have a will, then in many of those estates, someone will petition the court and a judge will appoint what's called an administrator, typically one of the heirs of the estate. Same role, just executor if they were named in a will, administrator if there was no will, and a judge appointed someone once they petitioned and asked to be appointed as the administrator. And then there's another little scenario here. And again, I'm in Louisiana, and I'm going to go over our Louisiana rules. I suspect, for those of you who live in states outside of Louisiana, your rules on what are the rights and obligations of executors and heirs are probably somewhat similar. The procedures may vary and do vary from state to state. So I'm going to go over our Louisiana version, but if you live in another state, I'm sure you'll find this helpful as well. And so we have executors, we have administrators, and then we have independent executors and independent administrators. So these days, since 2001, many years ago, virtually all wills written state that the executor can be an independent executor, which means they can perform more functions without needing a judge to approve every single act that an executor makes. But in general, unless I note otherwise, what I'm about to go over with you applies to a person who's in charge of settling an estate, whether they're an executor, an administrator, an independent executor, or an independent administrator. Okay, enough of that out of the way. So the first point that I want to make, I don't want to just go right to the things blew up. What recourse do people have? I can't go straight to that without first stating that, look, the executor needs to take their role seriously and they need to follow the rules. And so, when estates settle fairly quickly, without a lot of difficulty, without people going nuts, without everybody lawyering up, clearly an executor, as part of fulfilling their duties, really should gather all of the participants together on the front end. And there's lots of different ways to communicate. There's conference calls, there's group emails, there's, quite frankly, get everybody together physically in a room. And there needs to be clear communication. Something like, all right, here's what the will says, here's what the assets are, here's what the debts are. It's kind of my understanding that these are the steps that we're going to take from start to finish to get this matter resolved. Yes, things are going to come up along the way, but let's get everybody's, these days, let's get everybody's email. And as we make progress, I can send out group emails, keeping everyone posted on our progress. If you have a question, just send a group reply or reply all back. That way there's, real open communication and nobody's wondering, what are they saying behind my back? What are they doing behind my back? I'm not hearing anything. They must be stealing my inheritance. So that really open communication goes a very long way. In fact, that's the only way I get involved in the settling of an estate is if on the front end we can get everybody involved, create a plan as to the most efficient way to get everything settled from start to finish, get buy-in on the plan from everybody, and then just get things done. Okay, so that's, and then the other point is when stuff comes up and there's disagreement in the settlement of the estate, there should at least be an attempt to resolve the matter without, court interference, without judges having to get involved, because that's when it can be a real mess. But sometimes, these things can't get resolved without court interference, and so then we have to make sure the parties understand, what their rights are and what the rules are, and so everybody can take the appropriate action that they need to take to, protect their interest in the estate. Okay, so I'm going to go through, I think, 3 things here that I think heirs and executors ought to be aware of, so that if it gets to that point, they can take the appropriate action without a lot of stress and without doing the wrong thing that comes back and bites you later. So one of the remedies, heirs have in a probate, or in Louisiana we call it a succession, when things don't seem to be going right, is any kind of interested person in the estate can demand an annual accounting of the executor. So in that annual accounting, the executor's got to, in writing, put it out, file it at the court, with showing the money and the property in their possession, any kind of revenue, receipts, and disbursements that that the executor has taken in or dispersed into or out of the estate, and all of the participants, all of the heirs, all of the interested people in the estate, get a copy of that accounting. And so they can on anybody on their own can demand that annual accounting. Now, if you need more than that, on an application to the court, a court can require the accountings at more frequent intervals than annually. So sometimes that's just hey, we need our accounting. We need to know what's there. We need to know what you've taken in. File that. It'll get filed into the record, and so that's one area. If these things, if there's a stall for months or years, and an heir is totally in the dark because the executor is not communicating, then certainly it's reasonable to request that annual accounting, or if necessary, request that a judge order accountings at more frequent intervals. Okay. Next step, a little bit more serious, is removing the executor. And we've got some rules on that. And so let me go to, whenever I quote some rules, I like to go to them. So it says the court, and the court. People ask me, what do they mean by the court? It means the court, means a judge. The court may remove, and in our statute it's called succession representative, and that's the broad term that includes executor, administrator, independent executor, independent administrator. I'm going to insert the word executor because we're just using that word for now. The court may remove any executor who is or has become disqualified, has become incapable of discharging the duties of his office, has mismanaged the estate, has failed to perform any duty imposed by law or by order of court. All right. The court, on its own motion may, and on motion of any interested party, shall order the succession representative sought to be removed to show cause why he should not be removed from the office. Okay, so you can't just by yourself remove an executor. you can file a motion at the courthouse, and then there'll be a hearing where the executor has to prove why he or she should not be removed. So if you're going to ask an executor to be removed, there's got to be some basis for it. And maybe 3 years of delay is enough. Maybe didn't file the annual accounting when requested. Maybe they sold some estate property for less than fair market value, and that adversely affected some of the heirs. So anyway, there could be a number of reasons. Maybe the executor didn't pool the estate funds into an estate account, or maybe the executor spent estate funds on things they should not have spent them on. So there could be any number of things that an executor did or didn't do that might cause an interested person, like an heir, to seek the removal of the executor from office. So that was kind of a big deal, requires court hearings and all of that. And then the final area where sometimes heirs take advantage of this is, let me give an example. Let's say a person wrote a will, and in that will they left you their home. And to have the home retitled and put into your name, it's going to take some action of the executor and the executor's lawyers and you to get all of the appropriate court pleadings prepared, get all the appropriate signatures, and then get that filed at the courthouse, and then get the judge to sign the appropriate court orders, and then get that recorded in the land records to make you the new owner of that home. And let's say the executor is they're not communicating with you, they're stalling, nothing's get done, and you want to get the home that someone left you. And maybe they died 6 months ago or 2 years ago, and it's just not getting done. So there's a provision in our rules that say that this says that, okay, at any time prior to such and such, the legatees, and in our example, you are the legatee because the home was left to you and things just aren't getting done. The legatees in a testate succession, person had a will, may be sent into possession of all or part of their respective legacies upon filing a petition for possession as provided in such and such, except that the proceeding shall be contradictory with the executor. Upon the filing of such a petition, the court shall order the executor to show cause why the legatee should not be sent into possession. Okay. So that's where you're like, come on, man, I was left an inheritance, and you gotta get off your rump and do what you need to do so I get my inheritance, whether that's money or stock or real estate or whatever. So so you on your own can, again, you'll have to get a lawyer, but file a petition to the courthouse, and then there's a hearing where the executor would be required to prove why you should not be put into possession or named as the owner of that particular or those particular assets. And if the executor can't show why why that house should not be put into your name, the judge is gonna order that it be put into your name. So that's another piece of recourse that non-executor heirs have when the executor's just not getting the job done. All right, so again, I always just preface this because I really, 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 really hate to see families get torn apart as a result of these, estate settlements. Really want to emphasize the open communication from the get-go, and keeping those lines of communication open all the way through the process, so there's never any distrust, never any lack of communication, never any I'm not hearing anything, I don't know anything, so they must be mismanaging things. Those are the thoughts going through heirs' heads when they don't have that complete trust and they don't see that open communication. And then, everybody lawyers up, and then it just goes on forever, and kind of everybody loses. So, all right, a thumbs up if you could smash that. That would be really fantastic. And then we'll see you tomorrow.